Hey, it's Richard James here with James Law Firm, going to talk about the decision of buying a business. If you've already made that decision, in what industry, then what do you do next? If you haven't started already, you better read about that industry, especially in the local economy where you plan to operate. Read about who's in the space and read about valuation. How are these firms valued based on its revenue and profitability? Second, you need to assemble a team. You should have a banker. Probably whether or not you plan to finance part of the acquisition or not. You can always go down that road and look at your options. A banker will have the information you need on how to finance the purchase, including through conventional loans or SBA loans. They're the best resource for that. Second, a financial guide or advisor, perhaps a CPA, perhaps an outsourced CFO type who can examine the books and records and financials of the target company. You should also do that. But if you're not a financial expert or in the financial industry, you should lean on that type of advisor. And finally, of course, an attorney. An attorney understands not only the drafting of the document to acquire the business, but can help you with due diligence, both financial and legal, to examine what the target has been through legally, lawsuits, making sure that it has complied with legal requirements, and help you understand the structure of the purchase of the business. Those three are the big three in buying this business. So, what do you do next? Well, if you haven't had contact with the target, contact the target. Also consider, do you know these people? Then it's much easier to approach the idea if you know them. But otherwise, contact the target. If you learned of the business through a business broker, then contact the business broker. However, I caution that while the business broker always wants the dealings to go exclusively through that broker, I advise against that. You need to meet with management. You need to talk to them and see and hear their aspirations for the business, their outlook, and negotiate the terms. If the broker wants involvement, that's fine. But you're the one who's going to put your money and resources and time, reputation and energy and sweat into this purchase, not the business broker. So state your interest, especially if the business is not for sale. You've got to state your interest. I'm looking for a business to acquire in your industry, and I have interest in your business. Also, you should offer a non disclosure agreement. I would not wait until the seller or the target requests one. Show that you're interested and that you mean well by offering that non disclosure agreement. Obviously, if you already have a business and it's a competitor, then that's even more important because you want to assure that target and its principles that you're not out to get information for financial gain or profit. Next, you need to ask for financial due diligence. Let's see their financial statements. You would want to see a profit and loss statement for the current year, the prior 3 years is what I recommend, and the tax returns. And you want to be able to reconcile what's on the tax returns with what's in the financial statements. That's another area where your financial advisor should be involved in that. Also, you want to see a balance sheet, see what assets it owns, see what assets it has leased, see its capital structure, its equity, its debt, what liabilities does it have, and also a statement of cash flows. While a business may have debt, you want to determine whether it is servicing that debt and see what cash flow that business generates from operations. A business can generate cash from the operations and then use that cash totally to repay its debt, its financing section of the statement of cash flow, and distributions to investors or the purchase of capital equipment. So the company could be making money generating cash, but you might see that its cash on the balance sheet from 1 year to the next is very similar. So that would not tell the whole picture. If it started with $80,000 in the bank in year one and ended the next year, year two, with 85,000, you'd think, well, did it only make $5,000? Possibly not. You want to see where that cash flow went. Ideally, it comes from a statement of cash flows, which is not a statement that many business owners of small businesses use in operation. It is a generally accepted accounting principle or GAAP financial statement that is required, but small businesses often don't use it. So you're going to take all this information, you're going to review it with your banker, with your financial advisor, and determine, assuming that numbers are correct, what kind of offer would you put together to acquire this business. And you want to do that via a letter of intent, ideally, and you want to make it subject to financial due diligence. The goal of due diligence would be to review the financials and the other aspects of the business, such as employees, liabilities, its healthcare and benefit programs, all aspects of the business to justify that purchase price based on the risk involved with that company. Some companies have different risk. There may be significant product liability or environmental liability, for example. That should be factored into the purchase price. If you offer a letter of intent, then you should also ask for an exclusivity period whereby the seller or target will not market its company to anyone else for a period of time while you conduct that due diligence. So you're going to discuss all that financial information with your advisor, your attorney, and your banker, and come up with that offer price. It's not a firm offer, it's just the contemplated purchase price. Again, you make that, it's not really an offer as in a contract sense. It's basically a contemplated offer. Let me clarify that. But you place that in a letter of intent to encourage the target to continue discussions with you. Also, very important is you need to determine what you're offering to buy. When you buy a business, that is just a colloquial term. You need to know what you're buying. Are you going to buy the assets of that business into a new company that you form? Or are you actually going to buy that company, the stock or the membership interest of an LLC, and take over that exact same legal entity? That's very important. It's important for liability purposes and tax purposes. For liability purposes, if you acquire a corporation through a stock purchase or an LLC through a membership interest purchase, you're getting the whole box. You're going to get that whole box. Here's a box. You're going to get the whole box. Whatever's in that box is what you're getting. You're getting the good, the bad, and the ugly. If there are unknown liabilities in that company, like breach of contract or employee harassment, congratulations, you've taken over that box and you're opening it. If you're buying the assets of the business, then you take that box and you choose which assets you would like out of that box, and you assume only those liabilities that you're willing to do, like accounts payable, for example. Well, obviously, the business going concern, you're going to pay those accounts payable and probably do that through the closing process, whereby receivables and payables will get credited to the seller and afterwards to the buyer. Now, if you acquire the assets of the business, when you pick and choose those assets, you get to take the purchase price and you allocate it to the different assets that you acquired. There could be hard assets, land, building, equipment. There could be intangible assets, which is really what's left over and what you're buying, which is a business that generates cash flow. And we call that in the accounting and legal world goodwill. When you buy a building and equipment, you get to depreciate that on your tax return, known as write-offs. Write it off. The same with goodwill. You get to expense that over 15 years under the tax code. So those are tax benefits for the buyer. Even with equipment, you might can expense all or much of that in year one under certain special tax provisions. So you can see the tax advantage of buying the assets. If you buy the corporate stock or LLC membership interest in certain circumstances, you're not actually buying assets, and you don't get to take that purchase price and depreciate it or expense the goodwill over time. Instead, you have a basis in your stock, which is not subject to depreciation. You should see that buying the assets on the one hand and buying the stock on the other hand is not economically equivalent. So you would not go to a target and say, I'll buy your business for $4 million, and then say whether it's stock or assets. You might instead buy the stock for 3 million and the assets for 4 million, because you get to depreciate and expense that 4 million over time. And the net after tax effect for the seller of that business may be even better under a $3 million purchase, for example, than a $4 million purchase of that business. So it's very important to determine what you are buying. And that's all we have for today. So, in summary, you've made the decision. You need to assemble that team: banker, financial advisor, an attorney. Make contact with the target. Offer that non disclosure agreement to give assurance to that seller that you're going to review his confidential information for a proper purpose. Determine what you're buying: assets or stock. Thank you for listening in. Contact me at James Law Firm in Conroe, Texas. Thank you.